Well, the legal standard was the fact that every person that has offered testimony to the committee, we've tried to work with them. But it's the committee's standards that we adhere to, not the other individual.
Okay, on November 19th, did Mr. Meadows send you a letter clearly communicating a list of topics on which he was willing to provide responses to written interrogations?
Well, in all deference to Mr. Meadows' counsel, then, he can say it, but it's left up to us to accept it as a committee.
Mr. Chairman, I'd like to make sure that we enter into the record all of the committee, all of the chairman's responses to Mr. Meadows' attorney, because in addition to what the ranking member is referring to, the committee has engaged with Mr. Meadows' counsel multiple times, providing with him lists of topics about which we'd like to question him that are clearly non-privileged. And if he has a privilege claim he needs to make, he needs to appear and assert it on the record. But his refusal to appear at the deposition that was scheduled when he requested it be scheduled at the end of multiple exchanges back and forth made his assertion of that privilege on the record impossible. And he has never indicated to us any justification for his refusal to appear to discuss non-privileged materials, and that's because he has no basis for which to refuse to appear to discuss those materials.
Without objection.
Okay, Mr. Chairman, has Mr. Meadows provided you with 1,139 documents, 6,836 total pages, and a privilege log for any documents withheld?
He has provided the committee with a number of documents.
Okay, did Mr. Meadows also provide 2,319 text messages and a metadata from his personal cell, 20 documents from his personal computer, and a privilege log for any withheld text messages?
Well, to the extent that the numbers you quote are correct, those documents are what we have. The question, Mr. Ranking Member, for a lot of us is, now that we're in receipt of those documents, we wanted to talk to Mr. Meadows about them. And that's why we wanted to get him before the committee for deposition, and he's refused to come.
On the subpoena in question, did the committee issue it for law enforcement purposes or legislative purposes or both?
I would say for legislative purposes.
Okay, that's what I assumed. During our hearing on the Jeffrey Clark criminal contempt resolution, you and your colleagues repeatedly said that Clark could not raise executive privilege pursuant to Trump versus Thompson because Clark was not the one in court, but Mr. Meadows is in court. Is that correct?
That's correct.
Okay. And well, again, during the same hearing, you and your colleagues repeatedly referred to the need for document production in order to continue your investigation. If that's, and I'm sure that is the case, but then why are we advancing a measure here that's purely punitive? That is, the committee's not pursuing civil enforcement of the subpoena. Why not the civil course? Why the criminal course?
Well, clearly the criminal choice is what the committee made. We see the lawsuit merely as a delaying tactic on the part of Mr. Meadows. And we have given him, as I've said earlier, every opportunity to come to the committee. We negotiated with him. And at the last moment, he said he's not coming, and then he filed suit, which is his choice. We don't have to, as a committee.
Yeah, no, again, I'm just trying to be clear on this because you clearly had a choice to make. And I think when you choose the criminal course, you assure you're not going to get cooperation. When you choose the civil choice, you might. So I'm just trying to understand why not try that first, civil contempt, as opposed to criminal contempt.
It was a decision that the committee made to go the criminal route.
Okay. Thank you very much, Mr. Chairman. Thank you, Mr. Chairman. I yield back.
Mr. Torres. Dr. Burgess. So, Mr. Thompson, just to your last statement, that there was a choice that the committee made to go the criminal route and not the civil route. Did you have a hearing? Did you take a vote on that?
Well, we take a vote on everything we do, as a committee. The committee looked at it, the choices, obviously, we could do a number of things, we could do nothing. But we felt in the interest of getting as much information as we could, we pursued the criminal, route. It's the more expeditious route. The civil, would probably end us up in the years of litigation, which would delay the work of the committee.
So is your ultimate goal for a criminal referral to a branch of law enforcement because you don't have the force of the Department of Justice?
No, once we pursue the criminal, it's out of our hand. It's Department of Justice effort after that. We've done it one other time and successfully. But if Steve Bannon decides to defend himself in court, that's independent of our committee. Our goal is to try to get to the facts and circumstances that brought about January 6th.
Okay, to that point, let me just ask you, are there other documents you're pursuing to get to that end, to achieve that end? Are you looking at correspondence and emails from the mayor of Washington D.C. to the decision to not have protection here on the Capitol?
Yeah, well, the mayor is scheduled to testify before our committee. So, I mean, if you know of someone that we ought to bring before the committee to testify, our process has been open. We get suggestions from a number of people.
Well, I will give you these two suggestions. The Speaker of the House and the Senate Majority Leader, Mr. McConnell, had the obligation of protecting the Capitol that day. As a member of Congress, extremely interested in what data they sought, what if there are discoverable items in emails or texts or other documents. I expect your committee to pursue it with just the amount of vigor they're pursuing what many of us see as a purely political process. If you really want to get to the answers, if you really want to protect the Capitol against any future attempts, as Mr. McGovern keeps alluding to, why would you not go to the source, the two people who are tasked with the protection of this institution?
I'll yield to the vice chair.
Thank you very much.
Wait.
The committee
The question is to the chairman.
Well,
You're in charge of this investigation.
I'd like to add something, Mr. Burgess. I'm sure you won't mind if I do, in the interest of transparency and getting to the facts. Our investigation, as the chairman has noted multiple times, is very broad, gets at exactly the issues you've described. I'd be happy also to forward you the Senate report that has already been completed on those issues, on which we are adding. The issues around the security at the Capitol is critically important. I take issue, though, you describe go to the source. I don't believe that it is your view. I'd be stunned, frankly, if it is, and certainly the facts and the evidence do not bear out the notion that the source of the attack on January 6th was somebody here in the Capitol. This investigation has got to include what happened with respect to intelligence, what happened with respect to law enforcement, what happened here at the Capitol. But there is no doubt that the summoning of the mob to Washington, the provocation of the attack on the Capitol, and the 187 minutes during which we were under violent attack and President of the United States refused to act are indeed critically important areas where, for legislative purposes, which have been affirmed by both the Federal District Court for the District of Columbia and the Circuit Court for the District of Columbia, we have valid legislative purposes to get this information. And I think that with all due respect, my colleague fully understands that.
You know, I don't think that's an accurate assessment. I was aware of people talking just amongst themselves here in the Capitol, the day of the swearing in, the day after the swearing in. Are you worried about what's going to happen later in the week? Do you know about the people that the Proud Boys are going to be here? I did not know. I did not can't say that I actually knew who the Proud Boys were, but these were topics of general discussion going on here. So if you know that, and look, we've had bad protests here at the Capitol before. I was here when the Affordable Care Act went through the legislative process. You don't think we had some really upset people outside the Capitol during those days? Of course we did. This is it's what we do here. But where was the preparation for what everyone seemed to know was coming? Why did it stop? And that is the question that I hope.
Will the gentleman yield? Will the gentleman yield?
I will not. This is important. This is the question that I hope you, as an investigative committee, if you were to do your work, Mr. McGovern keeps talking about the next one, the next one, the next one. Let's protect ourselves against the next one by understanding where the deficit were prior to this one. And Mr. Chairman, I just asked a copy of the letter from the mayor of Washington, D.C. to the acting U.S. Attorney General and the acting Secretary of Defense be made part of the record.
Without objection.
And I yield back.
I think, did you want to respond? Yeah,
Well, let me just say that I don't know how you can draw a comparison between the Affordable Care demonstration and what occurred on January 6th.
Right.
I mean, people broke into this institution. They harmed people. They did all kinds of things. Look at any video, Mr. Burgess, that you want to see. This is not the America that we live in. I am thoroughly concerned that for some reason people did that. And with House Resolution 503, we are tasked with the responsibility of looking to the facts and circumstances of what happened. So I say, if you have additional witnesses you want to suggest, get it to us. But we'll do our work. We'll produce a defensible product based on the facts and circumstances behind what we come up with. And it's not going to be easy, because just like Mr. Meadows started off engaging the committee and stopped in midstream. I don't know if it was the former president saying what he was saying and what he put in his book was fake news, but he stopped right in the middle of an effort that our committee legitimately started negotiating with him. And after a former President Trump made the statement fake news, we never got another word from Mr. Meadows.
Mr. Perlmutter.
Article 3, Article 2, Section 1. This is the President's oath. I do solemnly swear that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Then Article 6, Clause 3, for all of us, we shall be bound by oath or affirmation to support the Constitution. We all take an oath. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I will bear true faith and allegiance to the same, that I take this obligation freely without mental reservation or purpose of evasion, and that I will well and faithfully discharge the duties of the office on which I am about to enter. So help me God. You know, I'm surprised, because I think what we're going to get next from Mr. Meadows is probably something like we got from Mr. Clark about the desire to take the Fifth Amendment. Because 18 U.S.C. 115, following Article 3, Clause 1, treason against the United States shall consist only in levying war against them or in adhering to the enemies, giving them aid and comfort. Treason is defined, going back to dictionary. Treason is the crime of attacking a state authority to which one owes allegiance. And what you've described is the minute Donald Trump said fake news, all of a sudden everything stops because there's a pledge of allegiance to Donald Trump above and beyond the Constitution here, which really is frightening. In 18 U.S.C. 115, which is why I think that we're going to see the Fifth Amendment being pled, whoever, owing allegiance to the United States, levies war against them or adheres to their enemies, giving them aid and comfort within the United States or elsewhere, is guilty of treason and shall suffer death. I mean, this is a death penalty statute. Or shall be imprisoned not less than 5 years and fined under this title but not less than $10,000, and shall be incapable of holding any office under the United States. And just the memos that have been disclosed to this point, in my opinion, are treasonous. And we've danced around this a lot, and we talk about obstructing Congress and things like that, but this was an effort to have a coup, to overthrow the country, to break the pledge of allegiance we make to this country and to the Constitution. I really am disappointed in Mr. Meadows. We always had a good working relationship here. He has two masters, Donald Trump and the United States of America, and I could see he's in a pickle about that, but it's the United States of America and the Constitution of the United States to which he owes allegiance, and I hope that he will fulfill his oath that he took as a member of Congress and the oath that he takes as an officer of the federal government to uphold the Constitution. With that, I yield back.
Thank you. Ms. Fishbach.
I'm just going to associate myself with the comments of the ranking member, and I will have questions for Mr. Armstrong when he arrives.
Okay,
Thank you.
Mr. Raskin.
Thank you, Mr. Chairman. After producing 9,000 pages of documents and saying he would comply with the committee subpoena, after agreeing to come and testify, and after extensive cooperation with the committee, Mr. Meadows' book, The Chief's Chief, came out, and President Trump exploded and called it fake news. And Mr. Meadows amazingly echoed that and agreed that it was fake news, and then he said he would no longer participate. He would not come and testify, to the astonishment of everyone on the committee, after saying he would come forward. Then he goes to court as a delaying game, as you say, Mr. Chairman, to try to throw a monkey wrench into the process he'd been cooperating with up until Donald Trump blew his top. His central argument there is that we have no legitimate legislative purpose in conducting this investigation. Okay, so that's the heart of the matter. I want to read to you guys Article 1, Section 8, Clause 15 of the Constitution under the powers of Congress. Congress has the power to provide for calling forth the militia to execute the laws of the Union, to suppress insurrections, and to repel invasions. Mr. Chairman, what do you make of the claim that the Congress of the United States, the House of Representatives, does not have the power to investigate a violent mob attack on the Capitol of the United States? What happened, how it got started, who paid for it? What do you make of that claim?
Well, I think it's just patently wrong. Clearly, H.R. 503 gives us the authority as a committee to look at all the facts and circumstances surrounding January 6th. And that's what we're doing.
Oh, it's very clear that House Resolution 503 commands us to do precisely what the committee is doing. But he's suggesting that it's somehow unconstitutional, that the Congress doesn't have the authority to investigate an attack on the government of the United States, an attempt to overthrow the election. Madam Vice Chair, what do you think about that claim?
Well, I think it's wrong, and I think the federal courts have also made very clear, just in the last 2 weeks or 3 weeks, that in fact the committee has stated a completely appropriate legislative purpose. So it's not an issue anymore.
Judge Chutkin said, presidents are not kings, and the plaintiff isn't president. Mr. Chairman, this really goes to the heart of our system, doesn't it? Do we have kings here? Do we have lords and nobles and friends of presidents who don't have to respond to congressional subpoenas or court subpoenas if they don't want to?
It is not up to individuals. We're a nation of laws, and clearly, because we're a nation of laws, people have to respect those laws and follow them.
Ms. Cheney, do we have to remind some of our friends what the American Revolution was about and what our Constitution says? Does our Constitution allow for kings, nobles, lords, people who are above the law?
Certainly it does not. No one's above the law. We're a nation of laws. And I'm just so struck, frankly, by something my colleague from Texas said a few moments ago in talking about the attack on January 6th, when he said, quote, "It's what we do here." No, it isn't what we do here. That's not what we do here. We can have debates and discussions about the law, about policy, about what is an appropriate role, but January 6th is not what we do here, and it can never be what we do here. And we have an obligation and we have a duty to ensure that the functioning of the government, the official proceedings of Congress, and it's difficult to imagine a more important official proceeding of Congress than counting electoral votes, that those who might attempt through either action or inaction to obstruct or delay those proceedings, that we get to the facts, that we understand what our legislative role is in protecting this nation, protecting the Constitution, protecting this Congress, from making sure that ever happens again.
Mr. Raskin, I'm from a part of this country where Congress had to pass laws so that people of color could vote. Because in my area, even Benny Thompson getting elected, it took a Voting Rights Act for that to occur. I'm a third generation person in this same little community I represent, but there has to be a place for our federal government when all else fails. And what you saw on January 6th was an absolute failure on the part of a lot of systems. And those systems are under review right now. So bringing witnesses to our committee, seeking testimony from individuals who have information, we're absolutely open to that process. We are not trying to tailor it in a particular direction. We want to get to the facts and circumstances. There's no ifs, ands, and buts about it. But the buck stops with our committee to come with an objective report based on the facts. And that's,
haven't you overseen something like 300 witnesses coming in either voluntarily or under subpoena, complying with the requests of the committee? The vast majority of the people have participated, right?
only 3 people at this point of the over 300 has not.
Ms. Cheney, the claim that a former president is not subject to legal process is extremely far-fetched, given the Supreme Court has found that the sitting president is subject to legal process. Do you remember a 1997 decision in a case called Clinton versus Jones? You remember the Paula Jones case?
I do.
And you remember the Supreme Court saying that the president of the United States, who's in office right now, is subject to civil suit? Is there any reason to believe that a former president is not subject to legal process, or even worse, that he can wave a magic wand and keep other people from having to testify?
No, and I think that last point is really critical, that there are issues that we are litigating here, there's no question. But people need to remember that the current president, as to many of the matters we are discussing, has waived executive privilege. Mr. Meadows has, in fact, received indication that from the sitting president, from the White House, that he needs to appear, he needs to testify. And we are, as we have said repeatedly, focusing on matters over which he has no ability, no possible claim of privilege. If he would like to assert privilege, he needs to appear and do so. A blanket notion that somehow I've determined I'm not going to appear because of privilege is not proper.
It has no basis in the law, right? Now, as you say, the executive privilege belongs to the President of the United States. Has President Biden come in to invoke executive privilege to stop Mark Meadows from testifying about what took place on January 6th?
No.
He is not, right? And has former President Trump, Mr. Chairman, although he has no say in the matter, but has he even tried to come into the committee to block the committee from taking Meadows' testimony? No. Well, does the Constitution, Ms. Cheney, have an office of former president?
No. Now, it is the case that there are some instances where a former president may assert privilege. But in those cases where the current president has made the determination that he will not be asserting privilege, and there is a process that the committee is undergoing, then the former president does not have the power to stop the Congress from investigating an attack on Congress and to prevent people from testifying who have information about that attack simply because of some notion that he can.
What if it would be embarrassing to him?
Right. Those are not privileges that exist in the common law. There's no basis for that.
Well, you say that a former president can try to raise a claim of privilege, which is exactly what Donald Trump did in Trump versus Benny Thompson. And now we have definitive rulings by the federal district court and by the DC Circuit Court of Appeals panel headed by Judge Millett on precisely that point. And Madam Vice Chair, I'm afraid you stated a little bit too categorically. I don't want people to think that a former president can just assert executive privilege and it works. He can raise the executive privilege as he just did, and he got slapped down so far at every level in the federal courts. And what's the analysis the court goes through? Well, it starts with the presumption, as you do, that under the American rule of law, everybody owes his or her complete truthful testimony to the Congress of the United States if it comes calling with a subpoena, just like in a court. That's the presumption, and the people have the right to know because this is a democracy. Now, what could be countervailing to that is some compelling interest provided by a president sitting, or an extremely compelling interest provided by a former president. And the DC Circuit Court of Appeals, with Judge Millett deciding, unanimously said not only was there no compelling or extremely compelling reason to overthrow the presumption that Meadows had to testify, Donald Trump did not even offer one. He could not even offer an interest. Well, what about the interest in doing this again someday? Is that a compelling interest that a president could incite a violent insurrection against the Union? Do we want to shield any information about that in order to protect a president from doing that in the future? Mr. Thompson?
I would hope not.
Ms. Cheney, what do you think about that?
No, of course not. And I think that the point that you're making is very important for people to understand. We all talk about executive privilege broadly. It's a qualified privilege. And when there is an interest, as there is clearly here, that is a privilege that does not shield entirely from someone's duty to testify. I would also say that we're at the point now where there are many of these details of what happened that we have heard so many times that I think it's really important for people to pause for a moment and recognize what we're talking about. When we say we need to ask Mr. Meadows questions about the President of the United States' effort to make Jeffrey Clark Attorney General, Mr. Meadows' questions about his discussions with members of Congress about that, and about what was at the heart of that determination, the effort to overturn the election results in Georgia and in other states. I mean, those are the kinds of things, if you had said a year and a half ago, I think people would have been stunned. But we have to be very sure that we don't become so accustomed to hearing the really grave details of what this president was doing, that we move on from the importance of understanding the specifics and the minute by minute of what happened.
Well, and let me close with a couple questions about that, Madam Vice Chair. Last night, the committee invoked a whole set of messages that were discovered in asking questions to Mr. Meadows, including Republican lawmakers and others sending frantic messages saying, we are under siege up here at the Capitol. They have breached the Capitol. Mark, protesters are literally storming the Capitol, breaking windows on our doors, rushing in. Is Trump going to say something? There's an armed standoff at the House chamber door. We are all helpless. Here's some more. This one came from Laura Ingraham. It was identified. Mark, the president needs to tell people in the Capitol to go home. This is hurting all of us. He is destroying his legacy. Brian Kilmeade, please get him on TV, destroying everything you have accomplished. Sean Hannity, can he make a statement, ask people to leave the Capitol? Donald Trump Jr., he's got to condemn this excrement ASAP. The Capitol Police tweet is not enough. Meadows responding, I'm pushing it hard, I agree. Donald Trump Jr., we need an Oval Office address. He has to lead now. It has gone too far and gotten out of hand. Now, Madam Vice Chair, why is it not sufficient just to say, well, he complied up until the point when Donald Trump essentially told him to stop complying? Why is his testimony further needed by our committee?
Because there are well, first of all, it's compelled by the subpoena. He's required by our subpoena to both produce documents and to answer questions, to appear to testify. And there are a multitude of questions that we need to ask him. We need to ask him, we need to understand what was going on, what were his discussions with the member of this body about making Jeffrey Clark Attorney General. Why did they want to make Jeffrey Clark Attorney General? What did he think about the letter that Jeffrey Clark was proposing to send to state legislators in Georgia to overturn the results of those elections? Why were Fox News hosts texting him, telling him that they needed to get the president out to stop this? Why did they think that the president was the one who could stop this? Because many of those same people now are in fact saying, gosh, this was just tourists. Or this was a false flag operation, another person on Fox News has claimed. So I think there are real questions about what those discussions were. I think there are questions we need to ask about what their plans were, what